Welcome to Legally Agile with Chris Werner.
Welcome to Legally Agile, the podcast for founders and executives of high growth companies who want legal strategy that keeps up with the business. I'm your host, Lisa Mosby, and we're here today with attorney Chris Werner, founder of Vidar Law. Chris helps high growth businesses navigate risk, seize opportunities, and stay legally agile without slowing momentum. In today's episode, we're talking about one of the hardest decisions a company can face in a serious dispute, whether to fight it through litigation or resolve it early, and how to make that decision strategic rather than emotionally. Chris, welcome. Thanks so much for being back.
Thank you.
Once a dispute has escalated beyond early discussions and formal litigation is underway, what changes inside the company from a strategic standpoint?
So I think, unfortunately, for a lot of businesses, and especially successful businesses, litigation is a fact of life. It's something that's going to happen. I think there's two categories of changes. Number one is once there is a dispute, whether you've gotten notice that there's going to be a lawsuit filed, or there actually has been one filed. There's two categories of things that change. Number one is what you do about your information. So there's always what's called a litigation hold, meaning you have to stop any automatic document destruction. You need to preserve files and information. And that can mean a lot of things. So in this day and age, when I started practicing, which was more than 20 years ago, we had to worry about things like metadata in documents and in email logs and those types of things. Now, in addition to that, we worry about things like your AI history, what you may have done on social media, all of those kind of things you need to preserve. So preservation of information is important, and I will tell every single client this. I'd rather there be a bad fact or a bad piece of information that I know about than you trying to hide it from me or destroy it. I can deal with bad information. I can't deal with something that has been destroyed or hidden. And I certainly can't deal with something I don't know about. So that's one thing. Number two is once there's a dispute, especially if it's a piece of litigation or even an arbitration, you are going to have to spend time dealing with it. This is extremely unfortunate, especially for fast-growing companies. It is a distraction. It's going to take at least your top executives are going to have to spend time on it, but quite likely other members of your team will have to spend time dealing with the issue. So it will be a distraction to your company, absolutely.
And when leadership is deciding whether to push forward aggressively or explore resolution, what core factors should frame that decision? Cost, exposure, precedent, reputation, operational distraction, as you mentioned, or something else?
Yeah, so I think you have to put a lot of things into the bucket and decide how to proceed. So there's a couple of different categories. Number one, there are sort of minor irritation disputes, I'll call them. These are things where they're small, they're not going to affect your business long term. They may be irritating, they may be unfair, but they're small. The second category is big disputes. These things are not as easy to resolve. They are going to be a distraction to your company for a period of time. And potentially they are going to have a significant monetary value with them, yeah, one way or the other. And then the third category is what's commonly referred to as bet the company type litigation, where these are disputes that if you lose, you will lose your company very likely. And so I think what you want to do is look at what category you're in. And depending on where you fall on that scale, you're going to either want to think about quick settlement or figure out a way to make sure that you win. So um, there can be settlement in any of those categories. So, for example, if you have a small dispute, let's say a vendor or a contractor or even an employee, a former employee, makes a complaint against you. Um, Quite often, you will find those things to be unfair. You'll think, well, what they're saying isn't fair. It's not right. It's not the way things are. But if you can make the problem go away with a relatively small amount of money, that is a decision you probably want to make early on. The same goes for any of the other categories. If you can make them go away with a small amount of money, even if it's a bet the company type litigation or dispute, if you can find a way to get out of it with a small amount of money, you probably should. Litigation is risky. You can have the best facts and the best lawyers in the world, and either a judge or a jury can still rule against you. And I've seen it happen. And so you really want to think carefully about that. But getting back to your main question, I think cost is definitely a consideration. The amount of manpower you're going to have to devote to the dispute is a consideration. So if you have to take half of your people and have them working on this, that could be a real problem for you, especially if you're, let's say, a 10-person company. And then I also think reputational risk is a big deal. So a lot of my clients are in various stages of raising funds. A few of them are even thinking of going public in the near future. Litigation can be a negative to both your fundraising and to a public offering, even if you've done nothing wrong. And so in a lot of those cases, you will decide to spend some money to resolve the dispute quietly, in order to avoid that reputational risk that you may be facing.
Chris, where do you see companies overestimate their position and where do you see them underestimate it?
So that's very interesting. I think a lot of times especially with my clients, who are often very smart, they are very driven. A lot of them are founders who've started these companies, and made them very successful. I think with a lot of those clients, they overestimate their litigation position because they believe, and often rightly so, that they are in the right on these things. The problem is that they may not see, a legal risk that is contained in a statute that they weren't really aware applied to them. There may be a stray email somewhere that no one really thought much about at the time, but actually makes a material change to their position with the counterparty. And so I think just assuming that, well, I have a contract and I've done everything I'm supposed to do means I should win, or I didn't do anything wrong, so I should win. A lot of times I see people overestimating their position because they think I didn't do anything wrong, so I should win. And unfortunately, that's not always the way things work out. Um, I also do see people underestimate their position. So um, the opposite side of that is really going at it with fear. And the most difficult thing I see is that fear shows up right toward the end or when there's a big inflection point in the dispute. So you're about to walk into a mediation or an arbitration, or there is a really important case critical motion that's happening. Or the other side has said, listen, this is our last offer ever, and if you don't accept this, we're going to litigate for the next 5 years with you. Um, that's when I often see that confidence break, and clients will underestimate their position. They will think the aggressive stance by the other side means that they are vulnerable and should capitulate. And that's not always the case either. Sometimes it makes sense whether you're right or wrong, but yeah, that's the situation where I often see confident founders and business people start to fall apart and really underestimate uh, what their position is.
I'm curious, on the other hand, have you seen a situation where settling too early created long-term consequences that outweighed the short-term savings?
That's a great question. My default position for most disputes is to try to get to an early settlement, and the reason is legal fees and risk don't go away even if you have a strong case. However, I have seen a situation, several situations where the people have settled too quickly. Often this happens because it's an ongoing relationship or a long-term relationship, and the settlement is largely negotiated without counsel or with counsel, but there's discussions that go on without counsel being involved. And the risk here is that there are unknowns or things that you didn't anticipate at the time that you agreed to this settlement. So I want to be very careful here not to disclose anything, but I've had a situation where there was a financial settlement that was reached very early with two parties, and they had a very long-term relationship, and one side wanted to retain that relationship and also continue to think of themselves as a good person. And so they agreed to a settlement very early. And about 6 months later, we find out that there are a bunch of financial issues that they weren't aware of at the time they agreed to this settlement. And had they been aware of that, the settlement either wouldn't have happened or would have been structured very differently. But unfortunately, since it was over, there was no good way to go back. And the client ended up with a significant financial loss because of that.
So, how do you approach settlement discussions in a way that preserves leverage rather than signaling weakness?
Yeah, so, you know, when I was in law school, I took a negotiation class, and it was always, a lot of the focus there was about that leverage, right? Like, how do you not signal weakness to the other side, and how do you sort of position yourself to get the best deal possible? Um, as I've gotten older, I take a slightly different approach. I certainly don't want to signal weakness, but I do try to take a very open approach to my discussions early on. I think there's a value to doing that, and also identifying the non-monetary issues that may be involved. So a relationship between the parties that's non-monetary, but it is probably still important to the parties. The business reputation of each side also very important, right? Nobody wants to go in if there's a piece of litigation that's public, right? And nobody wants to have a public record that anybody could find that accuses your company of fraud or breaching a contract or something else. So discussing those non-monetary factors is often very helpful to get us to a productive discussion without giving away leverage. The other thing I like to do is very early on, especially if there's a draft settlement agreement or something coming from the other side, um, again, address those non-monetary terms that I'd like to work on, right? It makes it easier to start that discussion. Okay, can I get you to agree that we can set, let's say, the venue for any dispute, right? If there's a breach of this settlement agreement, where do we go? You suggested we go to AAA arbitration. I prefer to litigate in, the federal courts, right? Can we agree to move that venue? A lot of times that's a small issue that the other side can agree to. Then we look for something else, right? Like the wording of this non-disparagement clause, right? Like the wording of it is one-sided. Can we make this a bilateral thing where it goes the same both ways? Again, a lot of times that's an easy agreement. You get a few of those easy agreements and then you say, okay, well, let's talk about the financial terms of this, right? You've already got an agreement. The other side then is more willing to sort of listen to those financial terms, which is what you were really interested in the first place.
Pacing, stepping through, and gradually
Exactly.
moving in the direction. Makes sense.
Exactly. You want to make sure you just sort of say, okay, let's get some easy agreements first. Okay, now we've got people saying yes to each other. Now let's move on to the harder terms.
For founders who are facing an active lawsuit right now, what conversations should they be having internally before deciding whether to litigate aggressively or pursue a resolution?
Yeah, so I think a number of those things depend on the setup of your company. If you have, let's say, a board of directors, you need to make sure you're giving the appropriate disclosure to the board. If you have investors that are owed disclosure, you want to look at those disclosures. But I'll circle back to some of the things we talked about earlier. If you're deciding how aggressive to be, one of the things you have to look at is your budget. Obviously, financial budget for litigation is something you want to consider. If you don't have the budget to take the litigation all the way through to the end, you need to be looking for an exit. But on top of the financial budget, you also have to look at your team's time, right? So if you are the CEO and you're running a small company, do you have time to spend 10 hours a week talking to me about your case? Is that going to derail the rest of your business? And if not, if it is going to derail your business, again, you should be looking for that exit. One of the easy ways to sort of try to put some definition around what the litigation is going to look like is to engage counsel, right? You should probably have counsel that you at least use for various issues with your company. Ask them what the budget is. Ask them what the timing is. They're not going to tell you if you're going to win or you're going to lose, but they will be able to help you give some definition to that. But you really, really need to think about your budget, your time budget, and your money, the money budget that you're going to put into litigation.
Chris, we're going to leave it there for today. And I want to thank you again for your insights.
Thank you.
And thank you for listening to Legally Agile with Chris Werner. If today's conversation sparked questions about your own company, whether it's legal foundations, disputes, or getting deal ready, you can find more resources at vidarlaw.com. You'll also find a simple 72-hour dispute response checklist. You can share that with your leadership team. If you found this helpful, please follow the show and share it with another founder or executive who may benefit. And we'll see you on the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.